This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
Hello, everyone. This is Tom Fox. I'd like to welcome you to the FCPA Compliance Report on the Compliance Podcast Network. In today's episode, we travel across the pond to look at the very interesting Serco Graphics Deferred Prosecution Agreement entered into by the company with a serious fraud office in the United Kingdom. I'm joined by Sacha Harber-Kelly, MBE, a partner at Gibson Dunn in London, together with Steve Melrose, Senior Associate, to take a deep dive into this DPA. I think it will be most interesting for the compliance practitioner, particularly those with UK operations, as it really lays out where the SFO may be going in terms of its deferred prosecution agreements. It really lays out the legal requirements and all other indicia. I'm looking forward to bringing it to you. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Hello, everyone. This is Tom Fox, back for another episode. And today we are going to go outside the confines of the continental United States to have a podcast on a recent deferred prosecution agreement which came out of the UK and involved the Serious Fraud Office and Serco Geographics Limited. I have today with me Sacha Harber-Kelly. He's a partner at Gibson Dunn. Also, Steve Melrose, a senior associate. They wrote, frankly, what I think is one of the best client alerts on this issue. And so I asked them if they would be willing to come on to the podcast to help visit with us on this. So, gentlemen, first of all, with that incredibly long-winded introduction, welcome and thank you both for taking the time to visit with me.
Thank you, Tom, for inviting us. Absolute pleasure.
Thank you, Tom.
So could maybe we just start with a little bit of background on both of you all and the Gibson Dunn practice in this area. In the United States, we would call it a white-collar practice, white-collar defense. But could you just tell us a little bit about your practice and why you were interested in this deferred prosecution agreement?
Absolutely, Tom. As you introduced me, I'm a partner in the white collar and disputes practice of Gibson Dunn in our London office. Although I'm part of the global white collar investigations practice. So we help companies under investigation by authorities, whether in the United Kingdom or in concert with our colleagues in other jurisdictions when facing investigations by authorities such as the DOJ and the SEC. We help a whole range of clients from industrial background, financial services, tech, bio life science companies. So the full range of corporates facing regulatory and criminal investigations. As I say, we work part of a very broad international practice. And Steve is an associate in that practice in London.
So let's now turn to the deferred prosecution agreement itself. This is the fifth DPA, so there's been a relatively few number of them. And maybe I could just start with, could you all, you give us what you think is the significance of this DPA, and does it provide us really with any information that wasn't available in prior DPAs?
Maybe I can take that one, Tom. I mean, you're quite right. This DPA, it is the fifth ever DPA concluded in the UK since the regime was established in 2014. It's also significant because it's the only DPA we've had in the last 2 years since the Tesco DPA was announced in April 2017. It's also significant in that it's the first DPA that's been approved by a judge other than Sir Brian Levison, who was the judge who presided over the hearings regarding the four prior DPAs. I think it's fair to say, given how few DPAs we have here, that the significance of each DPA is perhaps magnified, in that each will be unique, novel, new in some way, and each will be subject to real scrutiny by practitioners like Sacha and myself, who will pore over them to see what it is that we can take from them.
So I was wondering if you might be able to walk us through the court's analysis.
Sure. And Tom, just to give some background to how the DPA process works in the United Kingdom as opposed to the United States, is that a DPA cannot be concluded in the United Kingdom without a judge approving it. And as part of that approval process, there is a private court hearing in which the judge looks at whether or not entering into a deferred prosecution agreement would be in the interests of justice, and if it would, whether or not the terms are fair, reasonable, and proportionate. And if in that private hearing he comes to a conclusion that the DPA is likely to be in the interests of justice and the proposed terms are fair, reasonable, and proportionate, the process then moves to a public hearing in which a formal approval of the DPA and its terms is granted, and a judgment is published where the judge is required to set out what his or her reasons were for finding that it was in the interests of justice and the terms being fair, reasonable, and proportionate. So in this case, looking at the first statutory test and what were the factors in this case which made it in the interest of justice, I think the first thing to observe is the court recognised as a starting point that the conduct was serious. The victim was a central government department, and the judge found from the facts put before him in the private hearing that the conduct alleged demonstrated what he described as ingrained conduct by the company. Nonetheless, the judge found that there were significant countervailing factors, which meant that those could be taken into account and balance the normal position that where there is a serious allegation and evidence supported, a company should be prosecuted. And in particular, the judge recognized that in this case, the company proposed to be subject to the DPA had promptly self-reported the misconduct, had cooperated throughout the investigation with the Serious Fraud Office, was a company that hadn't previously had any criminal past misconduct. The conduct itself was now aged, going back to 2011 to 2013. The company had made remediation in two ways. Firstly, it had compensated the loser, in this case, as I said, the Ministry of Justice, and it also implemented significant remediation processes to its compliance and procedure. And those factors were seen as sufficiently countervailing to displace the presumption of a prosecution and turn the position to one where the public interest was served, or the interests of justice were served, by not prosecuting the company, but entering into a deferred prosecution agreement.
And then the terms of the agreement, as you articulated, Sacha, there's a two-part analysis. And then,
That's right.
So the court has to look at terms. Are they fair and reasonable?
That's right. Perhaps just before we get to our analysis of the terms, I think that we could perhaps look at in a little bit more detail, if we may, Tom, on some of the detail of the positive aspects that the company was able to demonstrate. So, for example, as part of the cooperation, one of the requests which the company acceded to by the SFO was not to conduct employee interviews as part of the internal investigation. And that is a request which is an unusual one, although it's one which has occurred in a prior deferred prosecution agreement with Tesco Stores Limited, which was in fact the last or the fourth DPA concluded in April of 2017. And the significance of that request from an SFO perspective is it permitted the SFO to secure the first account from those who were suspected of misconduct, or alternatively may have been significant witnesses. And the SFO, certainly in many of its public pronouncements, particularly through speeches, emphasizes that desire to secure first accounts. So on this occasion, the company agreed not to interview its employees, but to focus upon a documentary review of the evidence and allow the SFO to go ahead and interview the witnesses and suspects in this case. Now, although, as I said, it's happened before in a previous DPA, I'm not necessarily in a position to suggest that this is a trend. We certainly know of cases which have commenced subsequent to the Serco investigation, where companies have been not requested to defer from interviewing their employees. And certainly the SFO will recognize that in many cases where misconduct or potential misconduct comes to the company's attention, that a company will need to interview people before deciding whether or not to bring something through the doors of the SFO. So they specifically recognize that in many cases that will be the conventional position. So this shouldn't be seen as a case which suggests to receive a DPA you may not interview your employees. What it suggests, however, is that where a matter is before the SFO and the SFO asks you to defer interviewing employees, that you will get credit for doing so. And that is perhaps similar to the DOJ's position in its declinations with disgorgement. One of the aspects that policy speaks of is deconfliction, and the authority in the US requesting, certainly on a limited time basis, the opportunity to interview people before the company does. I think that's the key here as well, that in fact, in any case in the UK, the SFO would be open and would be expected to limit the time that it requests a deferral of interviews by a company taking place. In the future, I think such a request will be limited to cases much like this, much like the Tesco Stores Limited case, where there was a relatively few number of subjects who the SFO wanted to interview. They were all domestic, and also the investigation was purely domestic. I don't expect this request to be made in cases where there are numerous subjects to be interviewed, where other authorities are involved, and where the interview subjects are dispersed across the globe. So I don't see this as a trend, but I see it as something that if you have a case with the kind of facts we're discussing here, you may be requested to observe that request by the SFO to demonstrate your cooperation.
Sacha, do you see within the court's judgment any type of weighing or giving any one of these factors more weight? Or are they relatively equal, at least in the court's judgment in the Serco matter?
I think in the Serco matter, I think it's really when you come to the conclusion in paragraph 47, where really the judge gives the broadest terms, what for him was determinative. And for him, the broad heading of what was determinative was a demonstration by the company of its integrity, or its newly acquired integrity after the misconduct. And he says the best way in which that integrity is demonstrated will involve self-reporting, full cooperation, willing to learn lessons, and the acceptance of an appropriate penalty. For me, the most interesting factor there is that he describes self-reporting as a requirement. Historically, certainly when DPAs were introduced, the government statements back in sort of 2013 spoke more about companies cooperating and accepting liability when conduct was discovered, whether that be by an authority or whether or not it was by the company itself that self-reported. We see, I think, over the years since the government introduced the legislation, an increasing elevation in the importance of self-reporting. Certainly in the time that I was at the SFO and when the DPA Code of Practice was published, self-reporting was a factor, an important factor, but nonetheless one of a number of factors which were taken into account. I think this judgment has perhaps elevated the importance of self-reporting to a new level.
Well, since you've gone to paragraph 47, that brings up a point I wanted to address with you, or at least ask you about, and that's the first two lines of paragraph 47, and I feel like I should probably quote those. And they read, "There may be cynicism in some quarters about the process by which a corporate entity can take advantage of a DPA. This cynicism is not well-founded." And frankly, when I read those two lines, I thought the court was addressing concerns raised about the SFO. But after listening to you, Sacha, it would seem that the court may have been, at least it's open to another interpretation, that the court was concerned about people being cynical about companies who received a DPA. Do you read that as well?
I think it's the latter, how you've just explained it. I think historically there has been a cynicism in the United Kingdom that not prosecuting entities, not prosecuting organizations, in particular companies, because it's not a process available to individuals, is seen as a cozy arrangement that prosecutors and companies can come together and agree, avoiding ultimately prosecution for what is criminal conduct. So I think that is where the cynicism comes from. But in reality, DPAs recognize, and the whole reason for DPAs is to, in fact, as this judgment says in the same paragraph, are available to companies who demonstrate that they have remediated their past misconduct and have demonstrated that through the positive steps as enumerated by the judge here, of self-reporting and cooperation, and the acceptance that they will pay an appropriate penalty and learn from their lessons. And I think if we look at the terms of deferred prosecution agreements, certainly within the jurisdiction of the United Kingdom, the terms of a DPA are usually more onerous than would be capable of imposing upon a company if it were convicted. If convicted, the only penalty available to a court is a financial one. Now, that may be a larger one than would be available or is offered on a DPA, but terms such as corporate remediation and the imposition of compliance monitors are not terms which, certainly under the present arrangements in the UK, are not sentences that a court can impose. So I agree with the judge that any cynicism in DPAs is unfounded.
So perhaps could we now turn to the terms and how the court analyzed whether or not the terms of the proposed deferred prosecution agreement were fair, reasonable, and proportionate?
Yeah, sure. I mean, as we said previously, the question of the applicable penalty was addressed by Mr. Justice William Davis in a relatively conventional way. Consistent with his opening observations regarding seriousness, culpability was assessed as high level, which is the first stage in the process that the judges follow in determining penalty pursuant to the relevant sentencing guidelines. In this case, the harm was readily identifiable as loss in the form of the revenue abatement not given to the Ministry of Justice. And here we saw the judge discount the penalty by 50% to reflect the cooperation that Sacha mentioned earlier, which resulted in a saving in the time as compared with the prosecution, and to encourage future self-reporting. Now, as we mentioned earlier, there was a significant amount of time that passed between the conduct coming to light in 2013 and the conclusion of the DPA, I suppose one may look at it in the sense that a prosecution may have taken another, 1 or 2 years. So in that sense, there was some saving to be had, and that was what was recognised in the penalty.
I was just going to follow up on compliance remediation and potentially reporting future misconduct.
Yeah, absolutely. And Tom, I think there is some interesting novelty to those two conditions. Firstly, as far as reporting future misconduct is concerned, this is the first time that there's been a term of that nature in a deferred prosecution agreement. On the other side of the Atlantic in the US, it's now a common term for companies to have that obligation to report future misconduct, but that is new here, so it is worthy of observing. And I certainly think that will now be a typical term of any future DPA in this jurisdiction. The other requirement on the company was ongoing compliance remediation. The ongoing compliance remediation is interesting, and it's interesting in that it requires the company to continue its remediation efforts with respect to each and every one of its compliance programs. Now, that is very, very broad. Historically, in the DPAs which have been agreed prior to this, it was restricted to those compliance programs which had allegedly failed. So if it was a bribery and corruption case, then the remediation focused upon the bribery and corruption processes and procedures. Here, it's all of them, and it notes within the judgment various different processes and procedures, including the anti-bribery and corruption processes, which of course had no application to the misconduct in this case. But the company has agreed, as part of this deferred prosecution agreement, to look at all of its processes and procedures. So that's novel, and query whether or not that will become a typical term in the future. Certainly for me, faced with this situation representing a client, I think one of the discussions I'd be wanting to have with the SFO is, in fact, whether or not that is fair, reasonable, and proportionate. If, in fact, the failure had happened in one part of the company's processes and procedures, that, in fact, any term should address that failure to be fair, reasonable, and proportionate. But nonetheless, it was approved, albeit with the consent of the party in this case. But it's certainly something which I think in the future companies need to be aware of, certainly a request by the SFO to go broader, and there may need to be some advocacy with the SFO about the appropriateness of that breadth. Interestingly also, both the requirement to report future misconduct and also the compliance remediation is group-wide. It's not focused upon simply the target of this deferred prosecution agreement, the subsidiary Serco Geographics Limited. It's an obligation assumed by the parent company, the Serco Group PLC. So that's novel. At first, I thought that might have been something which was purely fact-specific in the sense that we know from the judgment that Serco Geographics, the target of the DPA, the respondent to the DPA, is now a dormant company, and the judge makes the point that any terms affecting directly it would be of no significance. It's not there to implement processes and procedures or report anything because of its dormant status. So on the face of it, it would seem that it was because of the factual scenario in this case of that dormancy. But in fact, what the judge says in paragraph, I think, 42 of the judgment is that this requirement that these obligations be assumed by the parent company, Serco Group PLC, he describes it as an important development in the use of DPAs, which suggests here we have a judge who sees potentially in the future terms which require group-wide reporting and compliance improvements as being, within his view, fair, reasonable, and proportionate. So that's I think, a significant potential change to take into account in future DPA discussions in the United Kingdom.
And Sacha, I thought that point that you very well articulated in the client alert really was one of the most significant ones. And it's going to be interesting to see if for future DPAs follow that, but also how that impacts a company's decision going forward. The next area I wanted to turn to was, as referenced, I believe, in paragraph 43, was the postponement of the statement of facts. And that's typically not something we see here in the United States. So I was wondering if you might give a few words on what that process is and why it's invoked here or what it may mean going forward.
Yeah, sure. And maybe I'll take that one, Tom. I mean, it is clear here that the application for a DPA must include a statement of facts. I'd say it's standard to publish at the same time as the announcement of the DPA. Certainly was in the case of the first three DPAs that we had here. The statement of facts was postponed in publication. Was postponed in the case of the Tesco DPA and has been postponed here as well for reasons that Sacha might want to go into. What it means is that the statement of facts will have to be published at some point in the future. And it's likely that that will either be where individuals are tried and subsequently their sentences are announced or they're acquitted, or in circumstances where the SFO takes a decision not to charge. I think our preference and what it would have been more helpful to see is perhaps an anonymized statement of facts, which would give some information to members of the public and to practitioners so that they have some sense of what's gone on and what it was that led to the SFO to offer the DPA to Serco.
Yes, and you know, sort of going to Steve's point, what occurred here is the judge, because no decisions had been made to charge individuals, thought that the publication of a statement of facts now may be prejudicial to individuals who had yet to have a charging decision made against them. And if they were charged, it may prejudice their future trial rights. So that was the consideration that the judge gave and the reason for him not requiring the statement of facts to be published contemporary with the announcement of the DPA. But it does bring into play some interesting potential anomalies, as Steve correctly identifies in the Tesco Stores Limited case. The statement of facts was not published until after the trial of the individuals. And the irony in that case is the individuals all had the charges discharged against them. So on the day that they were discharged, a statement of facts was published in which they were named as the main protagonists in the conduct for which the company had accepted a deferred prosecution agreement. So in my view, I agree with Steve. I think it is cleaner to publish a statement of facts at the time that a DPA is made, that it be published in a way which anonymizes individuals, and to the extent that individuals are then later charged and tried. There is ample power within the trial process for the court to direct the jury that they focus their attention upon the evidence they hear before the court and not what they may find on the internet. And that certainly avoids what could happen again in this case, where individuals have not been charged. We have a situation that in 6 months' time, when the SFO have said they will make a decision regarding those individuals, they may take the decision that, in fact, the evidential standard against the individuals has not been met. And then at the same time, a statement of facts be published in which those individuals are named as the main protagonists in the conduct. So it leads to that really strange anomaly. And I think it's best dealt with head on by publishing contemporaneously with the DPA and doing so anonymously and directing juries in future trials to disregard anything that they don't hear before them in evidence in the trial.
Gentlemen, the information that's in this deferred prosecution agreement seems to me to, if not widen obligations or opportunities around DPAs, it provides a company who finds themselves under investigation with a real roadmap of things that they can do proactively during the course of an investigation to hopefully help drive down a potential fine and penalty and perhaps even garner a deferred prosecution agreement. And you talked about self-reporting, accepting responsibility, remediating, accepting the obligation of reporting future misconduct, and literally having an entity-wide enhancement or upgrade of your compliance program, not simply the corporation or area of your controls that may have failed. Would you find that to be a fair assessment, or would you perhaps take things in a different direction?
No, I agree, Tom. Those are certainly the key features, which I think come out in the judgment. One other thing which comes out earlier in the judgment is also a recognition, and I think this has been significant in all of the deferred prosecution agreements as well, is that the company essentially is a different entity to the one at the time of the deferred prosecution agreement than it was at the time of the misconduct. In particular, not just looking at its processes and procedures, but looking at how the individuals who attribute the liability to the company has been dealt with. And it was recognized in this DPA, as it has in historic ones, that those whose misconduct is attributed are no longer with the company, or where appropriate and their conduct wasn't so severe, have been dealt with by disciplinary processes. So I think it would be certainly difficult for any company to be able to persuade the Serious Fraud Office, the DPA, would be appropriate, and a court would be appropriate if the wrongdoers had not been appropriately dealt with according to the level of their misconduct. So that's another important, I think, characteristic to take into account.
Well, gentlemen, unfortunately, we are near the end of our time, but I've been visiting today with Sacha Harber-Kelly, partner at Gibson Dunn, and Steve Melrose, a senior associate, on the Serco Deferred Prosecution Agreement. Gentlemen, I was wondering if any of our listeners wanted to follow up with you all with direct questions or ask for additional information. Could they do so? And if so, how would they do it?
Absolutely. Tom would be delighted to speak with any of your listeners. You will attach to this podcast our client alert. At the conclusion of our client alert, all of our contacts here in London and also our colleagues in the US are included. So please don't hesitate to reach out in the first instance to Steve or me, or our colleagues in the US, who can then refer you to us as well if your questions are directly pertinent to this particular discussion, and would be happy to have that conversation with you.
Gentlemen, I wanted to thank you very much for not only writing the client alert, but taking the time to visit with me today. This has been a fascinating exploration. I think there's really some solid information in this judgment, and a lot for people like yourself, outside counsel, corporations, and compliance officers to consider in the Serco Deferred Prosecution Agreement.
Thank you, Tom, for having us.
Thank you very much.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. I hope that you will join us again next week for another episode of the FCPA Compliance Report. And you also check out the latest offering of the Compliance Podcast Network, which is Accountability at the Heart of Compliance, a podcast which I am co-hosting with Sam Silverstein. Sam's got some great ideas on accountability, and they're directly applicable to the compliance space. So check it out, Accountability at the Heart of Compliance. Both Accountability at the Heart of Compliance and the FCPA Compliance Report are produced by the Compliance Podcast Network. The FCPA Compliance Report is a proud part of the C-Suite Radio.